All right, we'll call the next case then, GENCOR Industries versus Fireman's Fund.
May it please the court, counsel. Good morning, Your Honors. My name is Dan Hayes from the firm of Biederman, Reif, Honig, and Ruff in New York, and I want to thank the court for allowing me to argue this matter before it as a visiting attorney this morning. I'd like to reserve 6 minutes of my 20-minute time, please. Your Honors, in this case, the trial court entered a judgment which, in our view, is internally inconsistent and contrary to law, and we're asking the court to reverse it. The plaintiff in this case is a property insurance company, FIREMAN'S Fund, which made several payments to its insured George Reed Company after an asphalt plant fire and an explosion causing damage to the plant itself out in California. Fireman's Fund then became subrogated to Reed's rights, whatever they might be, against GENCOR. FFIC tried a case against GENCOR in the Circuit Court of Orange County. That resulted in a plaintiff's verdict on theories of negligence and a breach of contract. Prior to the verdict, GENCOR's trial counsel had moved for a directed verdict on both counts, on the negligence count because of the economic loss rule, and the contract count because of the disclaimers and agreements in the written contract between the parties. The court below denied that motion without explanation. The court then entered a final amended judgment based on the verdict, which was drafted by FFIC and which, in our view, is a rather troublesome document. It's inconsistent. It recites two different awards against GENCOR, one based in negligence, which reduces the jury's verdict based on an allocation of fault against FFIC's subrogor Reed.
Counsel, when the trial judge removes the negligence count, doesn't that make your argument moot?
But it didn't remove the negligence count.
Well, it went to the jury on the negligence count, but when the jury came back, he wouldn't award damages on both. He awarded it only on the contract.
Well, if you look, that's the trouble with the document, Your Honor. It's our trouble in looking at it. If a person comes from the outside, say a judgment, somebody doing a judgment search, and looks at the document that I've seen, it says initially that judgment is entered only on a breach of contract claim. That is true. But then in the next page of the document, it says that GENCOR shall pay, words to that effect, on the negligence claim, the 60% of the jury's verdict.
It just seems to me that your only real legitimate argument is that the trial judge erred in letting both of them go to the jury rather than arguing about the way the final judgment was crafted.
Well, certainly that is the main point, absolutely. And the reason I bring that up is that the initial reaction to our brief by FFIC was that the discussion we have in our brief on the merits of the negligence claim based on the economic loss rule is irrelevant. Well, we think it's relevant because of the language in the amended complaint, and we'd like to get rid of that language on the law. So that's why we briefed the economic loss rule matter. Now, the judgment doesn't say...
Wait, you want us to strip out a part of the judgment?
As an alternative request, yes. The main request we have, Your Honor, is that the judgment be reversed in its entirety based on the law. And alternatively, if the court doesn't agree with that, at least that section of dealing with the negligence claim should be stricken. Well, the judgment doesn't say who is liable for this judgment in either case. It says that it shall not be exercised or executed against GENCOR in personam, but I don't know what that means, Your Honor, and I'm sure that down the line, people...
Means you can't go after them in persona.
Well, in personam, I mean, what's not defined here, though, is what you can go after in order to exercise this judgment. And so I see it as an attorney for GENCOR representing a potential problem in the GENCOR, just in the way it's drawn. FFIC asked the court below to add GENCOR's insurer Gerling to the judgment as a judgment debtor. That was denied properly, in our view, because Gerling had reserved its rights to this claim, and the Florida non-joinder statute doesn't permit joinder of a liability insurer under those conditions. Since then, I believe in May of last year, Gerling disclaimed liability for the judgment in toto. Let me turn to the merits on the contract claim first, and then on the negligence claim. There's one thing that's indisputably clear in this case, and that's that both theories, negligence and breach of contract, were based on the same facts and the same proof, and that is the actions of this Mr. Dixon, who was GENCOR's employee, who was doing final adjustments to the plant in California at the time when the explosion occurred. FFIC's theory during the case was he did those adjustments improperly, causing the plant to have the explosion, which caused the damage to the plant. And time again in the record and also in the brief, FFIC says that's the basis for our claim of negligence, and the only basis, that's the basis and the only basis for our claim of contract.
Let me make sure I understand your argument here. You're not asking, or you're not claiming that there was no breach of contract. You're simply saying if there was a breach of contract, that it was disclaimed by the contract language itself.
Yes, that's true. At that point, I was just defining what their theories are, and the theories are the same factual basis, negligence and contract. And then because of the disclaimer language in the contract, we believe that there is no contractual remedy because the parties agreed that risk of loss to this plant would pass after acceptance to Reed. And also there's a very categorical disclaimer in the contract that states clearly that the only remedies that the purchaser has are a limited remedy for a replacement within 6 months after acceptance. And after that, the language, I was going to read the language to the court because it was misquoted in FFIC's brief. I'll just read the first paragraph, if I may, because it goes on. Disclaimer and release. The warranties, obligations, and liabilities of GENCOR and rights and remedies of purchaser set forth in this warranty are exclusive and in substitution for, and purchaser hereby waives, releases, and renounces all other present or future warranties, obligations, representations, and liabilities, and the word is or in the text, which is obviously a typo, of GENCOR, period, and then it goes on and specifies some subcategories. But if it had nothing more than that paragraph, that one sentence, that would certainly be a categorical waiver of any remedy, including the claim for breach of contract, which was brought by FFIC in this case. And if we turn to the negligence claim, we dealt with the economic loss rule in Florida at some length in reviewing it. I think this indemnity insurance company case in the Supreme Court in 2004 is pretty clearly makes our point for us that since there was a contract, the parties were free to structure their own arrangement, their own remedies, and to disclaim and waive other rights that might be between them. And that certainly the purpose of the economic loss rule is to avoid an end run around those agreements by allowing a claim in tort and negligence. So when you have a contract and when the damage is to the subject matter of the contract itself, as in this case, the economic loss rule, functions to bar any claim of negligence. So that really, in a nutshell, is our position. We think both claims were legally vulnerable, and the court should have dismissed them on the request of the counsel below.
What about your offer of settlement? You going to address that? Where is it? My question is, where is the ambiguity in it?
In the offer of settlement and dealing with attorney's fees?
Yes, sir.
I'll withdraw that point, Your Honor.
You'll withdraw it?
I'll withdraw that legal point. I won't withdraw, though, the position that we've taken that the attorney's fees are not within the claim as allowed by the stipulation. This brings us into this, what again, in my view, is a peculiar situation where the company was in bankruptcy. In order to bring the suit at all, there was a stipulation signed in order to get around the discharge in bankruptcy, so that the only claim that was allowed under that stipulation was the main claim in the case, not a claim for attorney's fees. So our point is that the discharge injunction of the bankruptcy court remains in place to bar.
How does that stipulation override Florida law, which says if you give an offer of settlement and you follow all of the rules about giving an offer of settlement and you don't?
Well, it's an odd situation, and it was new to me, but and we briefed initially, I must tell you, the point that because the bankruptcy court had not modified its discharge injunction, the entire claim was barred. But we modified that, but we still come back to the point that without the stipulation under the law in this federal circuit.
But the stipulation doesn't control entitlement to attorney's fees. It's Florida law that controls that. How do you respond to that?
Yes, sir. We believe that you have to start with a discharge injunction, which would bar this case completely. And the only way you open it up and permit it to go forward is the way that they did, which was via the stipulation which was filed in the circuit court and never signed off by the bankruptcy court. So you have to look at the stipulation to see the terms, to see how far the discharge injunction essentially was modified by that stipulation. And that does not include the attorney's fees. No, it's a matter of federal law and how the stipulation modified the discharge injunction. I would like to reserve the rest of my time for rebuttal.
All right, you have about 7.5 minutes.
Thank
you. Good morning, if the court please. John DeRevere from DeRevere Hawks Black on behalf of Fireman's Fund Insurance Company and as subrogate of George Reed.
Can you start off by clarifying something for me? Who are you going to go after in this thing?
Gerling.
Pardon?
Gerling, the insurance company. We're in a deck action right now out in California.
Do you think that the judgment and everything is clear to that effect so that you can go after them?
Absolutely. We're going to live and die on the breach of contract claim. They've just P.S. They've taken the position out there that the standard CGL language that says assumed liability in a contract prevents coverage. And just as a total aside,
are you going to have to relitigate that in California? Or?
No, sir. We think that it's very clear that because Gerling defended GENCOR on a reservation of rights, as they are here. Interestingly, the comment was made that they've disclaimed coverage. Well, GENCOR is actually bankrupt. Didn't present any witnesses, didn't come and do anything in this trial. Gerling ran this case and still running this case.
Are you litigating the reservation of rights issue now?
No, sir. We are simply litigating. Now we have a judgment, so we stand in the position of a judgment creditor against Gerling, and we're having summary judgment on the 8th of August in front of Charles Breyer, who is Justice Stevens Breyer's brother. Kind of interesting opportunity out there. But yes, this is clearly between FFIC and Gerling. That's the bottom line.
But why in the world if the negligence count is stripped out of this thing, why is it even mentioned in the final judgment?
Your Honor, the basis for it, frankly, was because we knew that we were going to litigate the coverage claim eventually. I was hedging my bets, if you will, to say, in the event that there's an assumed liability argument, which I foresaw on the part of Gerling in the DEC action, wherever we're going to file it, I wanted to have something in there to say, well, alternatively, I might have the same damage, the same result. Frankly, I didn't think this jury was going to award comparative fault, but so the numbers would have been the same. I simply put it in there as a hedge against what might happen in the DEC action case. It frankly is of no moment, because the judgment in this case is entered solely on the breach of contract claim. It's an interesting factoid.
Where does it say that?
The judgment says specifically it's entered only on the only on the breach of contract claim, solely on the breach of contract claim. Because obviously I could not enforce a judgment, even though I had two separate counts. The damages are one and the same.
I'm just mystified. If it's going to be only on the breach of contract claim, why is there paragraph 2 at all? I mean, that tends to confuse me.
Well, I understand, but the bottom line is I can only execute on the contract, on the judgment on the contract, only for that amount. Again, interesting factoid. The verdict was what it was. The jury decided what they decided. There was two counts given to the jury, and again, I believe, and I think the court has appropriately pointed out, that we can get into the conundrum of the fascination, the philosophical discussion of the economic loss rule, but frankly, it's irrelevant here. We can go through those cases about Professor Prosser's argument that it's the twilight of contract and tort, and Sommer in the case we cited up in New York, the Sabaro yacht case that says post-manufacture you can get around the economic loss doctrine. But mostly the reason that people file negligent cases, frankly, is because there's something in the contract that they don't like. Limitations of liabilities or warranties, frankly.
Or they want to strengthen the hand of the other party so that the insurance carrier for the other party isn't going to claim.
Absolutely. Frankly, Your Honor, we want to try to settle this case and get around as many of the obstacles to coverage as possible. Now, unfortunately, we are where we are. So you have that argument about the negligence to say, don't worry about that assumed liability situation, even though we don't think there was assumed liability. We've got a negligence count in there. Call it what you will. In this case, the crux of this case, and the problem for GENCOR, respectfully, is that we believe that there's nothing in this contract that relates to this issue. Interestingly, when you look at the contract, and counsel read a little piece of it, but when you look at the warranty provision at page 39 says, subject to the limitations set forth elsewhere in this order, GENCOR warrants to purchaser that, at the time of delivery to purchaser, each product and each part manufactured by or for GENCOR to its detailed design shall conform to the applicable specification for such product or part and be free from defects. And then it goes on in the paragraph 6.6, which is the disclaimer, to talk about the disclaimer. And interestingly, counsel points out that there's a period after representations and liabilities of GENCOR. But he neglects to go on that said that the next sentence starts with, together with all other rights, claims, and remedies of purchaser against GENCOR, express or implied, arising by law or otherwise, with respect to any nonconformance or defect in any product and part. That by itself, if you start that quote sentence with together, it makes no sense. We believe that it's all one sentence. We believe you have to read it, representations and liabilities of GENCOR together with all other rights, claims, etc., relating to any nonconformance or defect in any product or part. If not, the sentence doesn't make sense at all. This was GENCOR's standard terms and conditions. We believe it unambiguously applies to defects. And in this case, there's no defect.
Were there any jury instructions to deal with that?
No. And that's the problem for GENCOR. Now they're coming to you and asking you to rewrite this contract, or alternatively saying, you know what, we forgot to ask the jury this issue. They didn't make the argument in closing. They didn't ask for any jury instructions. They didn't ask for a special verdict. At best, we think that this is unambiguous in our favor, in FFIC's favor, that it only applies to defects. And there is no defect here. There was no defective part or condition. The argument would be, for instance, that if 6 months, 8 months after delivery, and we know delivery was in 2000, the explosion was in April 2001, if George Reed's personnel were doing this calibration and did what Mr. Dixon did when he unhooked the main gas line, but he forgot to put a cap on it, and he let it come back and arc, and he filled the drum up with gas, and he punched the start button just like you would do on your barbecue, only this is a 100 million BTU system. He blew it up. If George Reed personnel had done that, we couldn't come back to GENCOR and say, well, golly, something bad happened, because they'd say, well, what's the defect, boys? Where was the defect? And we'd say, gee, there isn't any. Just like if somebody else came out to service this plant and blew it up, GENCOR would say, well, listen, where's the defect in the parts of the products? There wasn't any. So we think that this is unambiguously in our favor, and frankly, we think that GENCOR at trial knew that, and they waived they just walked away from the issue. But at best for GENCOR, it was ambiguous, and they needed to ask the jury the question. Was there a defect? Or somehow, do you believe that this situation is somehow controlled by the warranty? They waived it. They didn't bring it up. There was not a special verdict interrogatory. There was not a question asked for anywhere, and there was no argument in final. And you heard this morning, they admit that there's a breach. And so what they go back to is the risk of loss provision, which is really interesting, because that's at page 36, and it provides for insurance. Now again, as the court knows, this was a purchase situation of component parts. It's just like going down to Home Depot.
Counsel, don't we interpret contracts so de novo? Isn't that our standard of review? So
yes, you can, but if they are ambiguous, if a contract is ambiguous and summary judgment would not have been appropriate, then certainly the fact finder, and if you are the fact finder at the trial court level, then certainly you can decide that ambiguity. But in this case, at best, the finder of fact, which was the jury, should have been asked to make the decision. This risk of loss is another red herring, absolutely, because it says the purchaser assumes responsibility for insurance of all silo system components and equipment immediately upon delivery of the equipment into the hands of a common carrier. In cases when delivery of equipment to a site designated by the purchaser is to be made by GENCOR from the time GENCOR disconnects the tractor. Well, for sure, if I'm buying a product from you and you're shipping it to me, somebody has to have risk of loss during delivery. We have to decide if that's going to be you or that's going to be me. In this case, it was decided that once the parts got to George Reed had that risk of loss. And guess what? George Reed took the risk of loss and bought insurance through FFIC. And it was 9 or 10 months later, after the equipment was there and built by George Reed personnel in foundations and with additional parts, many additional parts, that Mr. Dixon came along and unfortunately and unintentionally, absolutely unintentionally, blew the plant up. And it is that problem, not the fact that during shipment that something fell off a truck that we're complaining about. And it's not a defect in the equipment. Mr. Dixon, in fact, took all of the safety precautions offline because he was trying to run what he called a dry run. And he was more shocked than anybody, honestly, that the plant blew up. But what he did was he allowed the gas line to be energized. He didn't know it. Gas dumped into the dryer. It had been warm before. It heated up. And when he pushed the button, the plant blew up. And P.S., by the way, not only the products and parts that were sold by GENCOR, but other products and parts, and lots of other expense that was incurred by George Reed.
Which was included in the jury verdict, right?
Yes, sir, without objection. And in fact, interestingly, below, GENCOR agreed, stipulated to the $959,000, quote, property loss claim. Didn't ask for it to be broken down in any way, shape, or form. Said, yeah, that's the number. We agree. The big fight, frankly, was not on liability because they presented no witnesses themselves on liability. The big fight was on the business interruption claim and the additional expense claim. That was the big fight in this case. And they did good. And surprisingly, the jury gave them 40% comparative on the negligence, which was shocking, but here we are. Doesn't really matter in the long run. I'd like also to go into the interest issue because we've got a cross appeal on that question, if I might. As the court knows, and originally the trial court entered prejudgment interest based upon a stipulated date for a date of loss, which we stipulated was July 1st, 2001, a couple of months after the explosion. And the reason we did that was that it was at that time that the plant got back up and running again. And so rather than trying to get into a difficult calculation of, when were the parts damaged versus when did you have the business interruption versus when did you have the extra expense, we just chose July 1st, about 3 months later. And the court initially took July 1st as the date for prejudgment interest at the then applicable interest rate, 11%, and ran it forward. At a later point, GENCOR found the 4th District case in Burns International, which is a theft case, versus Philadelphia Indemnity.
How do you get around that case?
I don't know, honestly, Judge. If you read that case, obviously there's a lot of other issues going on. And Philadelphia Indemnity's insured is a party in that case. It may be that the court was thinking that the interest prior to the date of the payment belonged to Philadelphia, not to Philadelphia Indemnity, but to the insured, if he was in the case. But I'm not sure exactly. It almost seemed like a throwaway comment at the very, very end of the opinion if you look at it. But Burns... Did
you find any other authority which were throwaway comments in a case? Or?
Well, it doesn't cite Argonaut, which is an amazing thing, Judge. Yeah. I mean, and the Argonaut versus May Plumbing case, as you probably well know, is a subrogation case. May Plumbing burned up the building. Argonaut Insurance Company paid the loss. I don't presume they paid it on the day of the loss, although it doesn't say in the opinion. But I have to presume it was sometime later. I don't know how much later it was. But the Supreme Court chose date of loss in a subrogation case. Now, they certainly could have chosen date of payment, but they didn't. And Burns doesn't try to distinguish in any way, shape, or form Argonaut. I think Argonaut applies. And I'm not sure, with greatest respect to this panel, that or the panel down at the district court, my district court down in the 4th, that you can just decide that Argonaut doesn't apply without giving some rationale. And the difficulty here, in this case, frankly, with the whole argument that date of loss shouldn't apply, is that, frankly, it lets GENCOR off the hook because George Reed purchased insurance. I don't think it can be gainsaid that if I was here representing George Reed, not FFIC, just George Reed, that the date of loss would be the correct determination for interest, because George Reed would have lost that and GENCOR would have been, quote, holding that money, holding that benefit from that date. The fact of the matter is that FFIC insured George Reed. They did the right thing. They went out and got insurance for their property. And there's a $155,000 delta between what the court decided was the appropriate interest and interest from the date of loss. So it's significant. But what that means is that really Gerling, not GENCOR, because we know that GENCOR is a fiction here. They're in bankruptcy. And it's Gerling, the insurance company, says, you know what, we would rather have FFIC bear that loss than us pay it on behalf of our insured. And what it says is you're better off if you don't get insurance, because then the defendant doesn't get the break. But if the plaintiff, if the damaged victim gets insurance, well, the defendant gets a break. I don't think that should be the law of the state. And again, we can talk about the theories and the good and the bad, but Argonaut says what it says. Argonaut has been the law in the state. It hasn't changed, and it is the law on subrogation. Again, respectfully, if the Supreme Court has a mind to decide to say there's an exception for insurance companies, like the Seventh Circuit did out in the case that was cited by GENCOR, great. But until the Supreme Court does that, again, most respectfully, I think that this court is bound by the decisional law and precedent that comes out of the Supreme Court. We think and believe and ask that the court affirm the judgment. This issue about the negligence theory being in there, while it might be helpful for me in my settlement negotiations, frankly, with Gerling, it's of no moment. We can only collect on the breach of contract claim. The judgment should be affirmed, and the original interest award of $722,264.12 should be reinstated. Unless there's any other questions, I'd like to sit down.
Thank you, counsel.
Thank you.
I just have a couple of comments, if Your Honors, please, on the amount of compensation due FFIC as sub-regee. The Burns case is, of course, the case we think is better reason. There is potential conflict with the Supreme Court case. I'm going to just leave that to the court. I'm not going to take the position that I can distinguish between a Florida appellate court and a Florida Supreme Court. That might be overstepping my invitation here a bit. But certainly the Burns case appears to us to be better reasoned for the reasons that is set out in that Chicago case. Contrary to what you just heard, FFIC arguably should only recover, and not in this case, but should only recover the monies that it's paid out and interest on those monies. It didn't pay out from the time of the loss. It paid out on a schedule of 3 different payments, and that's when interest should start to run. I would like, though, to bring the attention of the court back to the contract that's at the heart of this case. We heard a lot from Mr. Van der Veer, very interesting information, but most of it irrelevant. I'd like to point out a few things. These services that were being performed according to the contract. Page 33 sets out the responsibilities of GENCOR in terms of doing these startup services, and it says that the value of the cost of these services are being paid for along with or in the total cost of the plant. Page 37, he read to you parts of a paragraph under the insurance paragraph, but he neglected to read this sentence. The purchaser, that is George Reed, is responsible for and assumes all risk of loss or damage by fire, theft, lifting, hoisting, or other casualty for the full amount of the contract and agreement with GENCOR. Each of these pages is signed off by the gentleman for George Reed. They agreed on that. And on the disclaimer, he's got the tail of the dog wagging this disclaimer, certainly, because there is only one reasonable way to read this paragraph, and it's a categorical waiver of any liabilities of GENCOR to George Reed or FFIC other than the limited warranty that we talked about earlier. I just don't see that that a reasonable person would be able to read that paragraph in any other fashion. So unless the court has any questions, I will conclude my argument.
Thank you, counsel.
Thank you very much, Your Honor.